The last thing I wanted to talk about is termination. Okay. I've already talked a little bit about the Minnesota statute, and this was the part of the talk where I was really going to focus on that. But I want to reiterate, the Minnesota statute mandates that a vendor cannot terminate an independent rep without some performance-based reason. Then it sets up all these notice and cure types of hoops that they have to jump through in order to effectuate a termination, even if they think they have a good reason to do it. There is a trapdoor in the statute, and it's called the non-renewal provision, and they can choose not to renew a contract. Let's say you have a rep relationship and you don't have any formal written contract, so it doesn't have an anniversary date. They have to give you, if they want to avoid having to jump through the good cause and cure hoops and those notice hoops, they have to give you 6 months advance notice, and they have to let you work that 6 months, and they have to pay you on every order that you book during that 6 months, regardless of when it ships. All right, that's the trap door. That's how there's a loophole written in the statute that allows vendors to avoid the good cause termination, and that's it. And the payoff is you get to keep the line for 6 months while you find something else to replace it. Yeah, the question is, he's an Illinois corporation. If he incorporates in Minnesota to take advantage of our rep statutes, does that affect the lines, his relationship with the lines that he already has? Yes, it's probably going to make them subject to our rep statute when you start writing business under that corporate name. What you need to do is send them notification that, listen, I've incorporated my business in Minnesota. I love the fishing up there. I love the weather. I mean, it's tropical, balmy St. Paul today. Here's my Minnesota EIN number. You know, my taxpayer ID number for the state of Minnesota as a simple notice. So now you're putting them on notice that you're now a citizen of the state of Minnesota, as well as Illinois. You know, and that's how they get notice. You don't have to share with them why you're doing it, obviously, but that's a simple way and a legitimate way to give them notice that you're now a Minnesota citizen. All right? Does anybody else have any questions? Okay, I have a multi-state territory that includes Minnesota. They peel Minnesota out of my territory and give it to another rep, but I have the rest. Yes. Yeah, that's not a termination. They haven't fired. They fired you from Minnesota. Right. This is the thing. Our statutes don't regulate if they peel off a piece of your territory, if they change your commission rate, if they take your largest account in-house. Our statutes don't deal with that. I suppose you could make an argument that you were terminated from Minnesota, but what you'd be making a claim for are lost commissions from your sales in Minnesota. Yes. But you'd still have the problem that you haven't been terminated. Right. And so there would be a built-in defense that we don't have to comply with the Minnesota statute for this because we didn't fire her. She's still our rep in all these other states, which is the very first federal decision concerning our rep law involved a gentleman by the name of Rodney Cooperman, who was a footwear rep. And he had Minnesota and Wisconsin as geographic territories, but 98% of his business was with Target. Okay? The company said, we're taking Target in-house. Thank you very much for your work. We're making Target a house account. He said, that's 98% of my business. That's 98% of my income. You've effectively fired me. They said, no, we haven't. You still have this whole state. You still have Minnesota. You still have Wisconsin. Go do your job and go build some business, right? He brought a lawsuit under our statute contending that taking 98% of his business by making Target a house account was what is called a constructive termination. You've effectively fired me. You've left me with nothing. We had a very smart federal judge in Minneapolis who said, you know, you may be right. So I'm going to let a jury decide whether a reasonable person under these circumstances would think they'd been fired or not. So you ask a panel of jurors, if you were working for me and I told you that I was giving you a 98% pay cut, would you feel like you'd been fired? Most people would nod their heads, yeah, I think I'd just been fired. The judge said it's a fact issue. I'm going to let a jury decide. And so they denied the company's motion to dismiss based on their defense that we didn't fire you. No, we're going to let a jury decide, which is effectively a win for the rep, okay? So there are those instances where something like that, peeling off a state, taking an account in-house, can equal, at least constructively, being fired, all right? But they're very fact specific. So if the account is 30% of your business, I don't know. If it's 50% of your business, I don't know. Mr. Cooperman's case was different because it was effectively everything. And it was a very clear case that, yeah, he'd probably effectively been fired. So I tell you that anecdotally. You know, it's the closest analogy that I can come to in terms of my experience to answer your question. Thank you, guys. I really appreciate your help. Thank you. Thank you very much. No, thank you.